Well, hello everyone, and welcome to today's FedSoc Forum. Today, on June 21st, 2024, we are excited to present a Courthouse Steps Decision program in the case of Moore v. United States. My name is Jack Apese, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the speakers on the call. After our speakers have given their remarks, we will turn to you, the audience, for any questions that you have. If you have a question at any point during the program, please type it into the Q&A function at the bottom of your screen, and we will handle those as we can towards the end of the program. With that, we'll get into some questions. I'll introduce our presenter today. We're delighted to be joined by Professor David Schizer, who is Dean Emeritus and the Harvey R. Miller Professor of Law and Economics at Columbia Law School. David, I'll start by asking this. What's the headline here? What should people know about Moore v. US?
So, Jack, it's great to be here. I'm really happy to talk about Moore. It's a really important ruling, but there's an irony here, and the irony is it's actually not about the issue that the court took. So the taxpayers asked the court to step in, basically to try to put the brakes on some soak the rich tax proposals that progressives been floating. But I really think the taxpayers chose the wrong vehicle here. So the court didn't reach those questions, though they did send some discouraging signals along the way that we'll talk about. Instead, what the court ended up doing is deciding a very different issue. The majority upheld the constitutionality of a 60-year-old effort to tax US multinationals on the income they earn overseas. So it really ended up being an international tax case in a way, instead of a case about wealth taxes and mark-to-market income taxes.
Well, then I guess a follow-up question for that would be, what are the progressive tax proposals looming in the background here?
Good. So why don't I just give us a fact pattern that'll help us to understand what current law is and then what these proposals are, because I assume some of the people who've joined us are not following this all that closely. So let's say we have someone, let's name him Jack, and Jack founds a successful tech company, and so he owns a big chunk of stock in the company. He didn't pay anything for it, so a tax lawyer would say Jack has a zero basis. And if Jack sells it for $10, $10 is what he gets, zero is what he paid, it's $10 of income. So let's say Jack has stock, it's now worth, let's make it a lot, let's make it $550 million. Good job, Jack. And so basically, as long as Jack doesn't sell his stock, there are no tax consequences. If under the current law, it's called the realization rule, you don't pay tax on appreciation until you sell. And there's an extra benefit, which is that if Jack holds on to it a really long time and ends up leaving the stock to somebody else in his estate, then when the heir gets the stock, they're treated as buying it. Even though they didn't, they're treated as buying it for its fair market value on the date of death. So let's say when our hypothetical Jack passes away and the stock is worth $550 million, there's $550 million of potential gain that the government could tax, but they never will, because Jack's heir will be treated as buying it for $550 million. If Jack's heir sells it the next day, no tax. So under current law, there are ways to defer, to delay, and possibly even to avoid the tax on highly appreciated stock. So a few things have been tried. President Biden proposed to make death like a sale, so that you have to pay tax then. Congress didn't want to do it. So the president's next proposal, and this is as recently as his last budget in March, but it's been floated a few times, is a so-called mark-to-market income tax. And the idea there is, instead of waiting for a sale, you just tax people based on its value at the end of the year. So this year, if on December 31, Jack's stock is worth $550 million, paid nothing for it, what you'd have is $550 million of income in that first year. Well, let's say the company doesn't do so well, and in the next year, it's actually worth only $450 million. And this is a key point, because this is a distinguishing feature compared to what we're going to talk about in a minute. Here, Jack would have lost $100 million, and he'd get a deduction for that. So this is an income tax still. It's not a wealth tax. We're not interested in what you own. We're interested in changes in what you own. It's just that it's an income tax that doesn't wait for a sale anymore. So that's one of these proposals that's looming in the background. A second is something Bernie Sanders and Elizabeth Warren have talked about. What they want to do is a wealth tax, which really means a tax on your net worth. So in that first year, Jack pays a tax, call it a 2% tax on the 550. And what they propose is the excess above 50 million. So there's $500 million. 2% of that is, oh gosh, 10 million. I'm probably getting that wrong. Yeah, no. Sorry, $10 million. Then the next year, when we're down to 450, you pay tax again. So unlike with the Biden proposal, oh, we lost money, give me a deduction. It's 2% of whatever it is every year. 2% of 400 million, that's 8 million. You're just paying tax every year. So these are two proposals that progressives have been pushing. And I think they motivated the taxpayers here to bring a test case to try to show the limits on the taxing power.
Well, I guess if we step back from that, then what are the limits on the taxing power?
Great. So this all started in 1787 because basically the Articles of Confederation didn't really have a national taxing power. Every state was asked to make what really was a voluntary contribution. And when contributions are voluntary, guess what? They tend to be less than the government needed. So the framers gathered in Philadelphia mostly in order to create a national taxing power. But it was controversial because there was a real fear that the federal government would become too powerful. So what did they do? They said, we're going to rely mostly on taxes on transactions. And the phrase in the Constitution, it's duties, imposts, and excises. Article 1 authorizes that. And an impost is a tariff, taxing imports. An excise is a tax on a domestic transaction. And so there's a rule in the Constitution. Congress can do that, but the tax has to be uniform throughout the country, which means that if I'm importing cloth in North Carolina, I pay the same tariff as Jack, who might be importing the cloth in Massachusetts. It's got to be uniform. So that is the main tax that they authorized, and it is the one with the more favorable rule associated with it. But as a backup, the framers said we can also authorize so-called direct taxes. Direct taxes are basically taxes without transactions. And there's a bit of a debate about the scope of what a direct tax is, but for sure it would include a real property tax. So if I own land, they can do a direct tax, they can do a property tax like New York State does for me, but there's a rule, and the rule is the so-called apportionment requirement. Any direct taxes have to be apportioned. And that is something that Congress generally doesn't want to do. Why? What apportionment means is that the revenue collected from a state, the share of a state's revenue, has to match the share of its population. So if Connecticut and Mississippi each have about 3 million people, and I think they do, and that's about 1% of the US population. So if you had a property tax, 1% of the revenue would need to come from Connecticut, 1% would need to come from Mississippi. But here's the rub. Mississippi is less wealthy, which means that the property in Mississippi is worth less. Maybe it's worth half as much as the property in Connecticut. If that's true, you actually need a tax rate twice as high in Mississippi in order to collect the tax. So you would have a higher tax rate in the less wealthy state, which is the opposite, of course, of what Bernie Sanders and Elizabeth Warren want. So if a tax has to be apportioned, it is not going to be appealing to progressives. And what the framers said is that direct taxes have to be, apportioned. So we've had an income tax a few times, including during the Civil War. It was upheld. One was passed in the progressive era. And in the case called Pollock, the Supreme Court struck down the income tax as a direct tax that had not been apportioned. They concluded that the income tax should be apportioned. So the response was the 16th Amendment. The 16th Amendment says income taxes do not have to be apportioned. So just notice they didn't repeal the apportionment requirement. They preserved it for direct taxes. They just said, but income taxes, that's another category. We have the indirect taxes, uniformity. We have income taxes, uniformity, effectively, and then we have these direct taxes that still have to be apportioned. So the questions looming in the background here are, when the progressives make proposals, are they income taxes that don't have to be apportioned? Are they, indirect taxes that don't have to be apportioned? Or are they direct taxes that do have to be apportioned and therefore aren't going to happen?
Well, I guess if we go back sort of more towards a focus on this case, more the United States, what issue was in the cert petition? Could you discuss that more?
Yes. So basically, what the taxpayers said they were doing was asking about a tax on appreciation without a sale. And they were basically saying income taxes have been authorized under the 16th Amendment, but we think income within the meaning of the amendment requires a sale. We think that there needs to be a realization, and they're pointing to a situation where taxpayers got a tax bill without having made a sale. So they thought they were bringing a case about that, but it turns out that it isn't really the issue in the case. I'll come back to that, and I'll just say specifically what the case was about. Charles and Kathleen Moore, two US taxpayers, bought shares in an Indian company, and the company did well, and their stock appreciated, and the company was making money, but they had not received a dividend, and they had not sold their stock. But they owned this stock during a period when Congress was considering a proposal by President Trump to change the way we tax international revenue of multinationals. And as part of that reform, there was a one-time tax imposed on the shareholders of foreign companies. And so the Moores said, hey, wait, we shouldn't have to pay this. This is a violation of the realization rule. But I'll just say a word more about the international tax rules at the time so that you understand what this tax was doing. The old rule was that if you were a US parent with subsidiaries earning money abroad, think Apple is based in the US, but Apple might have a company, a subsidiary in Ireland, and it is making money. As long as it made money in Ireland, the US mostly wasn't going to tax it directly. And instead, the rule used to be when the Irish sub paid a dividend up to Apple, the US parent, that's when it would be taxed. But until the dividend came, there would be no tax. So this turned out to be a very problematic rule, because basically what it did is it encouraged US multinationals to keep their cash outside the US, not to invest within the US. And so there are about $2.5 trillion estimated to be sitting in the overseas accounts of the foreign subsidiaries of US multinationals. So the Trump administration said, this is crazy. We're discouraging people from investing in America. We shouldn't do that. So let's eliminate this rule that you have to pay tax when, only when you get a dividend. And let's start taxing companies overseas at a lower rate so they won't complain too much about it, but we'll tax them as they're earning the money, and the dividend will be irrelevant. It won't be a taxable event. And then companies can decide, do I want to invest overseas? Do I want to invest in the US? We're not going to have the same effective bar to bring in cash back. So they did that, but they said, well, wait a minute. What do we do with the cash that's already overseas and that was already earned? And the answer was, well, impose a tax. It'll be a light tax, but we'll impose a tax on all of that past earning so that now when dividends come back, we won't have to tax them. So that was the mandatory repatriation tax that Charles and Kathleen Moore had to pay. And from their perspective, it was just a tax without a sale. And they said, okay, it presents the issue. But I think from Congress's perspective, this was a way to protect the US tax base from having companies avoid US tax by putting their money in Ireland.
Well, I guess for our next question, and this is helpful for our audience's awareness as well, but you wrote an amicus brief in this case, which said that the issue wasn't really presented here. Could you discuss why that is?
Yes. And so I recognized when I saw that the case had been taken that this was a confused situation that didn't really present the issue. And basically, what our brief, I wrote it for the American Tax Policy Institute with some really good partners in that effort. And basically, what we said was there are sales here, there are realizations here. This is not a case where there's a tax without a realization. The realizations are at the company level, down at the Indian company. And the question is not, can Congress tax you without a sale? The question is, can Congress treat the owner as the one who made the sale when the company sells? And so really it's a case about the relationship between the owner of a business and the business itself. And the point is that in another context, in the tax law, in a partnership, for over 100 years, the court has said, yeah, it's fine to tax the owner for what a partnership does. So if Jack and I form a partnership and the partnership is doing things and selling property and making money and it has realizations, the partnership isn't going to get taxed. The way the system works is that I pay my share of the tax as a partner and Jack pays his share of the tax as a partner. And so that model of treating the owner as the one, as a tax matter, who's doing the things the entity does, it's old and it's been blessed by the court in the context of partnerships. And Congress has been using it since 1962 and in ways before for the parent companies of foreign, for multinationals too. For US shareholders of a foreign company, they use the same approach because they can't tax the foreign company. So basically, what I think the issue really was here is it okay for Congress to tax a US owner on what its foreign corporation is doing?
Well, then I guess it's a good point to get to the issue at hand here. What did the majority decide?
The majority took the approach in our amicus brief. And actually it was interesting because in the oral argument, basically the full 2 hour plus was about this question. Justice Thomas led it off by saying, tell us the difference between realization and attribution. Because what if there are realizations here and they're just being attributed to the owner? So that was the theory of the majority. They said, we don't have to decide whether you can tax someone without a realization. That's the issue we thought we were taking, but we don't have to decide it here. We can't decide it here because there are realizations. And it's just a question of whether the realizations that the company is engaged in can be attributed to the owner. And we think the answer is yes, because we think this is like a partnership. And this is what has been happening for a long time in the international tax arena. So the majority basically said, we're not going to reach this question about realizations, and we're actually not going to reach these questions of progressive tax reforms and whether they're permissible. But we'll come back to this. I do think, nevertheless, that the court gave some heavy hinting that there would be problems with those tax reforms along the way. We'll come back to that.
Well, we did see that in this case, Justice Barrett concurred in the judgment and was joined by Justice Alito. What did she say?
So she came down a bit the same way in the end, but she got there by a different path. She started by saying, I do not think you can tax people without a sale. I think that under the 16th Amendment, a realization rule is required. So that mark-to-market tax that President Biden proposed, I don't think that works. She didn't actually mention that, but she basically staked out her position. And she said, but the court is right that we also have to face this question of whether we get there. And in some cases, she says, it could be that there's a realization down at the business entity level, and will attribute it to the owner. And the gist of her opinion was, I don't think that's automatic. I think the majority is laying out a test that will make that possible too often. And to my mind, it should be very rare, and it should be focused on abusive situations where people are avoiding tax inappropriately. But here, I will join, because to me, this is just like the regime the US has had since 1962, and the taxpayer conceded that that was constitutional. The taxpayer is saying this specific rule is different from the rest of the regime. We see no difference. Because of the taxpayer's concession, we'll go along with the majority. We'll attribute the realizations up, but don't get the wrong idea. We're not sure we'll do this very often. We're just doing it now.
Well, we also saw that Justice Thomas dissented and was joined by Justice Gorsuch. What did Justice Thomas have to say?
So basically, he said he did not agree that you could attribute the activity of a corporation up to its owners. So he disagreed with the majority that says that's routine, you can do it. I think he disagreed with Justice Barrett that you could do it in this situation. And he said, I don't think you can do it. And therefore, I do face this question of whether you can tax someone without a realization. And I think you cannot. I think that this is unconstitutional. And so Justice Thomas wrote the opinion that I think the taxpayers were looking for, but of course it's a dissenting opinion.
Well, Paul Ryan has said that a broad ruling for the taxpayer would cost trillions of dollars. Is that what happened here?
No. In other words, there wasn't a broad ruling, and the concern that he had was addressed. And I think his concern was about this international tax regime. The US doesn't want other countries effectively to steal American tax revenue by inviting multinationals to be able to shift income in that way. And so this is why President Trump was eager to shore up that effort, while at the same time cutting rates. The gist of it is, we want our businesses to be successful. We want them to compete, but we don't want them to be motivated to not invest in America. And obviously, Paul Ryan shared that view and was involved in that legislation. And so that did not happen. Basically, the regime that polices income shifting by multinationals was upheld. Part of the reason I think this was a bad vehicle is that perhaps inadvertently the taxpayers thought they were kind of taking on one issue, and they ended up accidentally threatening another important part of the tax law almost as a collateral damage. And so the court stepped in and said, yeah, no, this issue is about something different, and we think it's okay. But as to that issue that the taxpayers really meant to bring, well, that's different.
Well, thank you for that answer. And I'll just remind our audience, if you do have any questions, please just type those into the Q&A function, and we will ask those at the end of the program. But moving on to a different section, I guess, looking forward and discussing what guidance this decision might bring. I guess, what guidance, if any, did the court offer about a mark-to-market income tax?
So again, this is the one President Biden has proposed. Rich person has stock, it's gone up, tax them on the gains, it goes down, give them a deduction for the losses, there are no sales. Could this be done? So we now know that at least 4 justices would say it's unconstitutional. Justices Barrett and Alito in their concurrence in the judgment, and Justices Thomas and Gorsuch in dissent specifically said they think you need a realization in order to tax income. So I think there's an uphill battle here for that position. Justice Jackson wrote a concurring opinion, heavily hinting that she would be fine with it. The other 4 justices were pretty clear in saying, we don't decide this here. But if you are interested in counting heads, I think a big question is whether both Justice Kavanaugh, who wrote this opinion, and the Chief Justice would say that realization either is or is not constitutionally required. I think if one of them joins the other four to say it would be unconstitutional to have a mark-to-market tax, it would be unconstitutional. The government would need to hold both of them.
All right. Well, another question about guidance that is definitely important from this case would be, is there any guidance that the court offered about a wealth tax?
So I actually think the court was clearer on this one. And they did say, the majority, in the same way, we don't reach this. With the same sort of analysis, it's clear that at least four would say it's unconstitutional because it wouldn't be blessed by an income tax. And therefore, it would have to be analyzed under Article 1. And my own view as a wealth tax is a direct tax under Article 1, would have to be apportioned. But I think the four justices who've dissented or concurred in the judgment here would think that. And then the question is about the others. But what's interesting is during the argument, the government was asked whether ruling for the government meant that the court was upholding, would have to uphold a wealth tax with the same theory. And she said, no, 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 absolutely. And then she was asked, do you think a wealth tax is a direct tax and would have to be apportioned? And she actually said yes. She conceded that a wealth tax would be unconstitutional unless it would be apportioned, which was a very interesting step for the government to take. The concession won't be binding in other litigation, which is why I think it's very notable that the court, in their opinion, said, we don't decide this, but we want to note that the government conceded that it would be unconstitutional. So why add that? I read that as saying, subtext, and we think so too. So if I were advising Elizabeth Warren in the wake of this opinion, I'd say, with this court, no chance.
All right. Well, that seems like definitely a good summary and a good point to perhaps end on. It looks like we've come to the end of our questions, and with no additional questions coming in from the audience, or no, I spoke too soon. We do have a question from a guest here who is asking that the Moores didn't seek certiorari on their Fifth Amendment claim. Should they have? The Ninth Circuit shot down their due process argument based on Carlton, but in this person's view, Moore is nothing like that. The Carlton estate initiated its transaction in an admitted effort to take advantage of a loophole in a poorly drafted statute, while the Moore's investment was made in context of a decades-old law that no one thought was a loophole.
It's an excellent question. I would add another aspect to this. So what the statute did, the Trump Mandatory Repatriation Tax did, is it said all the earnings from before, we're going to tax those today. And they may have been earned over many years, and we're going to tax them today. The Moores made the argument below that that's problematic. It's problematic to tax people now on money that was earned in past years. And one of the arguments they made is, and what if you just bought it? What if I'm the person who owned the stock for many years while the income was piling up and I sell it to Jack? Congress passes the rule and they want to tax Jack, not just on money that was earned while he owned it, but what about the money that was earned when David owned it? And it's a pretty good argument. And I think under the Due Process Clause, there's a real question. Unfortunately, it's a lousy argument for the Moores to make because they owned it all the way through. So in any event, the Ninth Circuit rejected that claim. And of course, the Ninth Circuit rejected the 16th Amendment realization claim. And they only sought cert on the realization issue. They didn't seek cert on due process. I tend to think the due process argument was the stronger one. And I don't really know why they didn't seek cert on it.
Thank you for that answer. Looks like we have another question here. Do you have any comment on the disproportionate impact that this could have because of varying year-to-year income? For example, one could have a large income taxed in a given year, not have income against it, which to write off in the loss.
Yeah, so my opinion is that a wealth tax is a direct tax, which would have to be apportioned and therefore is not going to happen. And you need to be an income tax in order to avoid that. And to me, what an income tax means is not just that they tax gains, but that you have a meaningful ability to deduct losses. Because income is really about measuring the ups and the downs. And if all the government does is take a bite out of the gains while leaving all of the losses with you, I think that at some point that's not an income tax anymore. So it seems to me if you're going to have a mark-to-market tax, you've got to have full deductibility of losses without limitation. You wouldn't, want to say only against capital losses, but not against ordinary income. I think you'd need to do against ordinary income too. And you'd need to have carryovers so that people could use those losses eventually. And if you didn't, I think you'd have a real question as to whether it was still an income tax.
All right, well, thank you for your answer there as well. It looks like we have come to the end of our audience questions. So I'll just say on behalf of the Federalist Society, I want to thank our audience as well as David for being with us today and for sharing his valuable time and expertise with our audience. I also want to thank everyone for joining and encourage everyone to keep an eye on our website and your emails for announcements about other upcoming Supreme Court decisions that we'll be sure to be covering. And so with that, thank you all for joining. We are adjourned.